Hi, my name is John Szymankiewicz and I'm with Matheson & Associates and Beer Law Center. And today I want to talk to you a little bit about trademarks, particularly the different kinds of trademark applications and when you should do what. Now the first thing I want to point out is that when most people say trademark, what they really mean is U.S. Patent and Trademark Office, federal registration of trademarks. So that's what we're going to focus on today. So let me point out first that the law is you cannot register a trademark until you have used that mark in commerce, right? And in commerce, there's quotes around that. It's a very specific legal term. It doesn't mean what you think it means. For federal registration, it means are you selling that product using that mark at that time, okay? So let's say for a brewery, if you want to register your mark for beer, you have to be selling beer using that trademark at the time you apply, if you're going to be registering that mark, right? So what that means for a lot of breweries and a lot of folks that come to me for trademark assistance is that they're not ready to do that, right? They're just trying to lock down their name, their intellectual property around that identity first, right? For example, the licensing with a brewery alone takes 6 months in some cases. So for a brewery, again, you can't register that mark unless you're selling beer under it. So let's talk a little bit more though about the mechanics, and I'll come back to how you can actually start the process before you're actually selling beer. So mechanically, there are two flavors of trademark registration with the USPTO. The first is a text mark, right? So the words themselves are protected. If I have a brewery or a business and call it Third Street, if I trademark the words Third Street, the words themselves are actually protected. It doesn't matter what color font it's in, what size, whether it's black and white or color, none of that stuff matters. The words themselves are protected. Now that's different than a design mark. A design mark is like a logo, right? It can have text in it, but it's a design. It's a particular set of shapes, colors, something that make up your identity. So classic example is like the Nike swoosh, right? There's the swoosh, there's the word Nike over it. That's a design mark, even if it has the word text in it. So when you're thinking about applying for a registration, start first, and I've got a quick little flow chart up here, start first with identifying what kind of mark you're trying to register, a text mark or a design mark. Most of the time I suggest to clients first, focus on your text mark. Your text mark will give you the most bang for your buck, right? Because the words themselves are protected. Doesn't matter, again, color, font, size, nothing like that. Whereas a design mark, only that specific image is protected. You can get little tweaks around it, but for example, if you have a logo and your name around the top and that's what you protect, as soon as you remove the name, it's not protected as strongly. So the first thing you want to decide is whether you're going to do a text or design mark. Okay? After you've made that decision, and specifically, most of the time, again, I recommend a text mark first because the words themselves are protected, whereas a design mark, only that specific image is protected. And quite frankly, as businesses are getting started and trademark is an issue, this is the one that's most likely to change, right? If you decide, oh, I want it to look this way or I want it to look that way, well, congratulations. If you've already registered it, it's done. You have to do it again. Whereas your text, that's typically going to be your brand name or a flagship brand name, that's less likely to change over time. Once you've decided, text or design mark, here's where that whole registration, use, and commerce thing happens or becomes important. So you can't register the mark unless it's being used in commerce. But the USPTO gives us a way to deal with that. And that's called the intent to use application. And I've abbreviated it here as ITU. And the idea with an intent to use application is I'm not selling yet. I'm not really selling under this mark yet, but I promise I'm going to. I'm really going to do it. And I'm committed to this name, right? I'm committed to this mark. So you go ahead and file an intent to use application. It goes through exactly the same process as any standard application, but for a standard application, at the end it becomes registered. For an intent to use application, at the end it becomes allowed. And what that means is that the USPTO says, yes, as soon as they're using it in commerce, it will register. It's allowed to register. We just need that proof. So then later on, after you're using it in commerce, you can then register it. So what happens after that's allowed, you have 6 months to be able to show that you're using it in commerce for it to register. But at the end of that 6 months, you can ask for an extension for another 6 months. And you can keep doing that for a total of 3 years. The way I think about it is that the USPTO thinks if you can't get your stuff together in 3 years, you don't deserve trademark protection. But what that does, what that intent to use application does, is it holds your place in line. It makes sure everybody else in the world, when they do a trademark search, your intent to use application comes up. So they know somebody out there is planning on using that mark. So again, hold your place in line. And in fact, if you file an intent to use application, and then somebody else files an application to actually to register that same mark, they're going to put their application on hold until yours either registers or is abandoned. So the intent to use application is a great way to, like I said, hold your place in line, even if you're not ready to register yet, or even if you're not selling product under that mark yet, as opposed to a standard registration, which is when you apply, you have to be using the mark in commerce. Okay? Application, decide text or design, and then after that, are you going to file a standard application or an intent to use application? If you have questions, give us a call. We're at Matheson & Associates, 919-335-5291, or find us online at mathesonlawoffice.com or at beerlawcenter.com. Thanks again.